by Mr. Hartman, and opposition to that request was filed by Mr. Kilpatrick on behalf of the respondent. Sir, I did review your motion, and I believe it lacks the necessary requirements in the code section under which you filed it. I think that was raised in Mr. Kilpatrick's opposition, so if you could address that, sir, that's what I'm looking for.
Under the 657?
Yes, sir.
And what was your question about it?
I don't believe that any of the proceedings rise to the level necessary for me to grant promotion for a new trial. And so is there a specific section under 657 that you believe rises to the level?
Well, under 657, and for as far as the grounds for it, the irregularity in proceedings and the abuse of discretion.
So I did review your motion. Is there anything you want to add for the record that maybe wasn't in your motion?
Well, yes. First, I also have a letter here I would like to send to the court from my oldest son.
Objection, it's hearsay.
So letters from third parties are hearsay, and especially that was also not filed in support of your motion, so.
Okay, as far as the motion for new trial.
Yeah.
Okay, I believe there's like several key issues, that would support the motion for a new trial. And, I'd like to start with, the fact that Judge Webster, on his own motion, filed to recuse himself. And although, Judge Webster didn't disclose his reasons for recusal, I believe it was very clear by Judge Webster's prior ruling, there was a clear bias. It was very clear in the respondent's counsel, in his first proposed statement of decision, which I objected to, and showed not one finding of fact to support it. So my first issue with Judge Webster's refusal, as I waited almost 11 months to hear back for a response about the proposed statement of decision.
Well, let me interrupt you though, sir. I believe that happened after the trial that he recused himself.
No, he recused himself before he even before he got a decision. Like I said, he filed a proposed statement of decision. I objected. We waited almost 11 months, and instead of receiving the decision, I received a letter saying that he, on his own motion, was recusing himself. That's when it was reassigned after that. And then another thing about is on December 8th, 2022, Judge Webster said that he had nothing to do with discovery, and that it was just between the parties, and also that discovery starts when the case is filed. And so I objected to that on the grounds that I was not notified of the ruling. And Judge Webster told me that I needed to, if I wanted to present evidence, that I could do that on the trial on January 5th, 2023. But on January 5th, 2023, I was denied presenting any of my evidence that was already submitted in my trial brief that Mr. Canada had previously filed. And so I was then unable to present my case using relevant evidence that strongly supported my case. And by doing that, it prejudiced the outcome of the trial. During the trial on January 5th, I was repeatedly objected to with baseless objections that were all sustained erroneously by Judge Webster. I was then told I could not question the respondent about relevant issues to my case. I objected to that, and I brought up the relevant issues about rental properties, trust accounts, and Judge Webster immediately continued the trial to the 6th. And this is where another abuse of discretion took place by Judge Webster, because he allowed respondent's counsel to come back on the 6th and place the unknown document on the petitioner's table. And at that time, they didn't even know what to call the document. He was starting to call it a trial brief, and then Judge Webster said, no, you can't call it a trial brief. And then Mr. Patrick said, well, it's just a statement of law. Anyways, he's already arrested his case, and Judge Webster allowed him to reopen his case and to submit this and have it admitted over my objections. And that's after the fact that he already had denied me from presenting any of my documentary, evidence. So I wasn't even able to present my case in chief with documents that was already filed previously in my trial brief that showed, financial documents, marital bills, all relevant things to my case. And, then I was blocked from even bringing it up. In the end, Mr. Patrick called it a trial brief. So, I mean, like I said, when Judge Webster, continued the case to the sixth on the fifth, he didn't say anything about coming back with trial briefs or having any briefs. He just continued the case, come back tomorrow. And, he intends to do that just so he can come in with that document to try to overcome the, presumption of undue influence. And I think that's a clear abuse of discretion by allowing him to present documents after denying me from presenting any documents, especially that stuff that was already in my trial brief. Which clearly, if I couldn't present documents that was already previously, submitted in the prior case, in the prior trial, then there was no way I would be able to get a fair hand. It was like a one-sided decision, one-sided judgment. If you look at the judgment, this is how it's, out of all the supposed statements of decisions that he's created, they've never had no findings of fact, they don't have anything that supported. He left out, clearly half the cases left out of the decision. He doesn't put anything about the bank accounts, he doesn't put anything about the rental property, he doesn't put anything about the $85,000 I would put into a trust account. None of that. It's just the house. First, the house was sold and the money was put in some trust fund. There's $298,000, which is clearly wrong. So just upon that, I mean, there's not being able to present these documents that are crucial to my case. It's gonna have a clear prejudice against me. And being that Judge Booker recused himself, there's no way, it shows a clear bias on one end. There's no reason, and I don't know why he would wait 11 months to even recuse himself off trial.
But that, I don't think affects your motion, sir. Under 657, there's very specific grounds under which the court can grant your motion. And, I printed everything out, including the minutes, the briefs. I was the one that made the ruling on the judgment, and I don't see that it rises to the level of any irregularity in the proceeding. You disagree with Judge Webster's ruling, I understand that, but I don't know that that's the same standard for a motion for a new trial.
He recused himself.
Right.
And
But that was
before he even came
after.
to the decision, they're finding a fact. And also, the sixth standing, falls under the, abuse of discretion by not allowing me to present my documents that were in my trial brief was submitted. These documents, I wasn't even allowed to question the, respondent on the stand. So how could he even, make a ruling if I wasn't allowed to present, credible and reliable evidence?
Well, but if I look at the January 6th minutes, and I printed all these and reviewed it, it says that, the court had to terminate the hearing because of several severe interruptions, by you, and that disrupted the proceeding. So it sounds like the court made a finding that your conduct justified terminating the proceedings.
Well, that goes hand in hand with why he recused himself. I don't understand what his bias was. Clearly, he found that he couldn't, rule on the case and be impartial about it. There's some bias or partiality towards me or something, but he sustained almost every objection. There was, like I said, I was not allowed to question the respondent. I was not allowed to bring up credible evidence to support my case, which would clearly have made a big difference in the decision in the end if my documents were submitted, because I'm a citizen in this matter, and I was asking just nothing extra, just to be fair. We split the marital bills. I wasn't asking for anything that I'm not inclined to ask for. And, I wasn't even allowed to bring up my separate property, which I clearly got the deeds and all the financial documents to show, you know, my tracing. I was not allowed to bring that up, which would have a great impact on it. And then objection after objection after objection, you know, I mean, that was a huge bias and prejudice against me that created the outcome of it.
Right. And I think these relate, obviously, to your arguments in your motion. Mr. Kilpatrick, I did review your opposition, and sir, while you may have other remedies available, Mr. Hartman, you know, I spent a lot of time reviewing your motion and reviewing the standard under 657, and I don't think that your motion reaches the level. You may have other remedies, but I don't believe it's a new trial under 657. So your motion for a new trial, sir, will be denied, and you're welcome to seek the other remedies available under the law.
But not being able to present my evidence, my documentation and present my case, it's not an abuse of discretion.
I don't find that the conduct rises to the level based on my review. I believe that your own conduct rises to the court terminating the proceedings. At least that's what the record shows that I was able to review.
On the fence?
Correct.
One additional issue, I'm still holding money in trust, 100% of it goes to this department. It's been held in a separate segregated interest-bearing trust account for well over 2 years. It's caused a severe financial hardship for her. We would invite your honor to issue order today that we release those monies to this $100 in my private account.
That's untrue, Mike, and that's.
And additionally, he still owes her tens of thousands of dollars in watch charges that have occurred. So the residence he's in is going to be sold, and most of the profits will go to this department.
The judgment said all funds currently held shall remain in trust pending further order of the court. So Mr. Kilpatrick, I don't think that issue is before me, and Mr. Hartman needs a chance to, be heard on that. So if you wanna file a motion, you're welcome to, but that's not before me today, so I'll deny that request.
Thank you.
Alright, thank you both.
Well, Your Honor, like I said, this is what I was talking about, abuse of
Well,
discretion
Mr.
here.
Hartman, though, you may disagree with my ruling. You're now making the same arguments over and over, so